Dealing with various different types of trust. Let's talk about it. One of the definitions of sovereign is one who can control title to property. And if that is something that you decide that you want to do, put true title to property into a trust. You can express a trust, you can have an implied trust, or you can operate in trust. Trust law is the highest form of law. It basically deals with split title. Since 1933, we've all been dealing in trust law because all titles have been split. A great wealth of knowledge for understanding trust law is Weiss's Concise Trustee Handbook. You want to read some of that. Trusts can be implied or expressed. They can be oral or written. They can be constructed or resulting. This will point blank tell you the whole outlines and operations procedures and how to establish and create and deal in trust. It explains what trust certificates is, like your certificate of car title, like your certificate of birth certificate. Those are trust certificates that are issued. If you don't have true title to the property that you are putting into trust, you must understand subject matter jurisdiction. There is underlying basically strings attached to anything that you do not hold true title to. And it's great to understand some of the maxims of trust law, like a beneficiary does not have to be told that a trust exists. If you are basically showing the results that you are operating in trust, you are presumed to know that a trust is existing. In a trust, you can be the grantor, the trustee, and one of the beneficiaries. You have to have at least two beneficiaries, or it's not a trust if you are all three parties. That what is so powerful about a trust is because it has two or more parties, and through two or more witnesses may everything be established. Another great maxim is that a trust cannot fail for lack of trustee, which basically means that even though there is no trustee, there cannot be a failure in the trust, and it is exist and established. Now, according to the Second 13th Article and Amendment, there is no such thing as involuntary servitude. So though you may appoint a trustee, that does not mean that they have to accept that responsibility. When you start dealing in equity, in chancery, in trust law, you are dealing in the highest form of law. Now, we all get deceived into the creditor-debtor mentality of banking terminology when everything is in trust. Houses are in trust. When you register your cars, your guns, your property, your estates, your businesses, everything is in trust. And basically the state is taking on the role as parents patre, as your daddy, until you take responsibility for yourself. And basically establishing your own trust and becoming your own law is being responsible. And that's what we're supposed to do. The state is the daddy of the U.S. citizen, and it will always be the daddy of the U.S. citizen. And what you can do with your own property is you can put your own trust together, and you can create and put titles into it and control it because you control what you create. You can have a sovereign trust. You can get your own parcel to your own land, outline the longitude and latitude of it, and basically start forming your own trust. You can apply for an EIN through the IRS in a republic sovereign state and get a sovereign republic state EIN. You can do this if you want to open up a bank account, but you must understand banking laws and terminology and etiquette and basically regulations if you're going to be involved in that sort of thing. Remember that Federal Reserve notes are someone else's property, and you have to understand what you're doing. You can establish a trust with an all capital letter name, just like your U.S. citizen looks, and it can be controlled by you, and it can be in a foreign jurisdiction, and it can hold true titles to property.